Hi, hello. Welcome to Telugu NRI Radio Wednesday Immigration Show every Wednesday evening 6 p.m. Central Time with Attorney LUCAS Garritson from Burgos Law Firm. So we are coming every week on Wednesday to bring the more USA immigration updates and future the information what will happen or what new rules are which be clarified in this every week Wednesday show. Today we brought a couple of topics and we will discuss with Lucas, and I think we had a good news on yesterday. Biden signed on the Trump initiated rule, and more interesting updates we'll get from Lucas. We will welcome to Lucas today's show. Hi, Lucas. Good evening. How are you?
Hi, Venkat. I'm doing well, Venkat. How are you?
I'm good.
Good. Thank you for having me, and thank you for all our viewers for tuning in this week at the same time, 6 o'clock on every Wednesday.
Yeah. So, Lucas, today we're gonna discuss about the October filing 485 adjustment of status and the 2021 cap process. And also we got a lot of inquiries, and we saw a lot of issues on 485 rejection and different WhatsApp groups. And maybe we will try more questions or more information. We will touch more information on 485 adjustment of derivative files got rejected.
Correct.
So we can go for step by step, and yeah, I want to hear the good news from you. What is the good news?
Well, good news is, as of yesterday, it's officially withdrawn the challenge from the Trump administration to withdraw H4 EAD. So we can now all rest, at night knowing that the program is still going to be enacted for, the foreseeable future. And, again, for those who might not understand what H4 EAD is, H4 is a derivative benefit or beneficiary of a principal H1B immigrant, usually a spouse or child. And then the EAD allows a person who is in H4 status, if the principal non-immigrant has an approved I-140 and the visa for the GC is not yet available, the spouse can go ahead and apply for employment authorization. So this helps, family unity, increased income for the family, more support that way. And, the whole purpose of the program was centered towards people who are stuck on these horrendous backlogs, waiting at EB2, EB3 categories. So now, it's a good victory moving in the right direction, keeping H4 EAD, but hopefully this year, if things progress like we expect them to, we won't need that, as much in the future, because we'll be able to address this humongous backlog that's been pending for some time.
Okay. So it means Trump brought this new rule on 2019, I think, end of the H4 EAD to end. But luckily, Biden moved forward as a good approach, good step to take. And so a lot of H4 holders happily work what they pursue or what they desire to work on, and respect to the working.
Right.
So is H4 EAD, we are talking about the H4 and H4 EAD, still we are in a situation who applied the H4 application, but still under process. It's taking the longer time. It's taking the more than 6 months and get the EAD. What do you think? Biden will remove the biometric? Even I see maybe one tweeting or something we'll hear the good news on H4 EAD. Do you have any information about the biometric and the future H4 EAD process? Make it faster to get EAD?
Well, that's a good question. Right now, I haven't heard any news officially of what would happen to streamline the application process, much like how they used to be 3 or 4 years ago. And unfortunately, at this time, we had a huge influx of people filing, their GC cases, and all of the GC cases are going to require biometrics also. So, we just increased the line by 20,000 plus, with all these recent filings. So unfortunately for H4 EAD, the process has been long. It's been getting longer, and now we can expect it to still progressively get longer due to the recent filings. So, it's a short-term pain that we have to endure, but long-term, I believe that this is something that will be addressed and fixed.
Okay. Yeah, Lucas, we can discuss H4 and H4 EAD related maybe after some time the show. Then we can come to the H1B Cap, the final rule. The president passed 60 days, right? It means, can you give the more information on that one?
Correct. So there's been a few policies right now, the regulations, rules that went into effect. And the president across the board, the first day in office, did a 60-day pause, so to speak, on it, the implementation of these rules. Now, DOL has already started the process of removing their final rule that had the wage rates increasing, the definition of an employer-employee relationship, et cetera. And what we've done is now, can you see me?
Yes.
I'm sorry. All right. So what we've done now is focus on, there we are. I apologize. I lost my train of thought. So we're talking about
the final rule, H1B Cap.
Correct. So the DOL rule was rescinded, and the administration has published a final rule to remove that rule, and which is good news. Now, the H1B fiscal year 2022 cap can still be impacted by this new rule. However, it seems like, and this is something that I think most people can appreciate moving forward from what we've endured the past 4 years, is it's a responsible person or leader who goes into a term and will look at the evidence of what the program needs, look at what the history of the program has been, and look at to the future of what the program should be. And I think it's irresponsible for someone to just go in and just say, I'm going to change everything back just because previous president changed it to this way. And I think that's what we're seeing right now. So there's some rules that we know just are outside the scope of what Congress intended. Those rules have already been in the process of being rescinded. The H1B Cap rule is, I think, still under review as far as the determination of what to do, and that's more or less what this 60 days allows. Now, I firmly believe that the rule will ultimately not be implemented in regards to this year's cap or in the future year's caps. But we still have to be prepared, and we still have to be ready that, we don't want to wait till the end of the 60 days, which would be right at the beginning of the registration period for H1B registration, and then be completely caught off guard with some new process or procedure. So it is still kind of, doing double work, but we always want to be prepared so we don't have any issues.
Okay. So as we are discussing about the H1 cap, the information, what do you think this 2022 H1B cap random process will get the random process, or it means, as I don't see last 1 week any update on H1B cap. Can you share if you have which process is going to be implemented by March for 2022 cap?
I would say, the traditional random selection process is probably the one that's going to go at the end of the day. I mean, that's a very high probability of what's going to happen. There's nothing official yet, so we can't say officially, yes, this will happen or not. But we have to, just wait and see how the agencies and the administration handle the change and what the processes will be. Now, another thing we need to look at is this year, due to last year and everything that happened with the registration process, along with other changes to, current regulations and memos and things like that, there was a tremendous amount of cases filed and approvals. And I think this year we're going to see a continued increase in filings. And I think that, the current system that's being used is the one that's the best suited for this. So, we'll just have to wait and see how everything goes.
Okay. So let we come to the October adjustment of status of filing. So what is the status as who applied in October 2020 adjustment of status? Do you see all or got receipt numbers, or do you see any rejections? If you see any rejections, what is the reasons?
So as we've discussed in weeks past, I think, obviously this agency works on a FIFO system, which means first in, first out. So of all the cases we filed in the first part of October, we've already seen receipts. Pretty much for the most of the month of October, I think we have receipts for everyone. And what we've seen so far, some of the early filings have already received biometric appointments and have approved EADs and advanced paroles. So they're going to, and a lot of the EAD and advanced parole approvals are going to be factored into where the person lives, depending on how long or how much demand there is for biometrics. Again, like we were discussing at the beginning of the show for H4 and H4 EAD, the demand for biometric appointments is really going to be a governing factor into how soon you can have your advanced parole and EAD. And I know a lot of people are stressed at the moment due to the fact they probably have family back home that might have health issues or anything like that, and they're waiting on these documents so they can travel. So we just have to be patient, and hopefully we start seeing more and more approved here shortly. As far as rejections go, we haven't seen any specifically with our office like this, but I know I've heard a lot of from other people where rejections have come in where maybe the forms weren't completed correctly, and the forms were rejected because, and usually I think the common denominator with this is going to be for family members where when you have your principal applicant, maybe the person who's currently in H1 that you're filing for, we select in the adjustment of status that we're filing for, employment-based, things like this. And from what I've heard, other people have left it blank because they think common sense would tell them that the spouse or kids are not going through that process because they're not employment based. They would be derivatives. But USCIS is rejected for those reasons. Maybe some other reasons would be the funds not being sufficient with the checks provided, maybe the wrong filing fee amounts. And these are all, varied cases. And for anything that's happened to anyone, I know it's worrisome. Don't panic. There's always a solution to every problem. And you have to, be patient with these processes and realize that, we did have a large number of people applying at one time. USCIS didn't provide much advance notification as far as what would be acceptable or not in certain, regards to some of these filings. And also at the same time, in years past, if there was something wrong, USCIS would return the package, but allow you to, unless there was something, just a tremendous error made, they would allow you to resubmit without losing your place in line. So a lot of these policies have changed where they're more drastic. And an example of this is for people who file for asylum status. Under the last president, they changed the policy where if one field, like your middle name, if you have a middle name or not, if that's left blank, they would reject the whole package. So you literally, if you don't have middle name, you have to put NA or whatever it is for every single field in the application. So, you're not alone. If anything bad happened or the case was rejected, it's something that can be resolved. It can, and we can, it just takes a little bit of time and patience, and we can get everything back on track.
Okay. Lucas, you provided a lot of information. Just I need to discuss step by step in the 485, the rejection, adjustment of status. The first thing is I would like to discuss with you regarding what is 3A and 9B. I hear a lot of questions. Maybe I hear a lot of rejection on this one. What exactly this?
I don't know the fields off the top of my head, but if I were to, guess, I would expect it's what I just said about there's a field where it asked, is this a family-based or employment-based? It goes on down to say if it's employment-based, are you related to, the petitioner, or do you have any ownership interest in the petitioning organization? Like I said, usually I think, common sense would tell you if you're filing an employment-based application for adjustment of status, that you would be looking at the principal applicant, and that each derivative, wife and kids, you wouldn't necessarily say it would be an employment-based, but we knew before probably this summer of those changes that were made in that regard. So we were able to mention that and have that correctly done. And I think, again, like I said, it's not the fault of really any other attorney who might have missed that. It's just they might have missed the announcement or news that came through in regards to that field, because in the past, that's how it was done.
Okay. So what if, let's say, due to some misrepresentation or maybe misselection of the options or maybe parts, so it got rejected for the primary applicant and the derivative applications. Let's say it means if any application got rejected, those are fall into the 2014 August priority date. The current is not priority date is your retrogression to take accept the filing 485 adjustment of status. In this case, will they reapply again on the same receipt number, or they should be wait until get their priority date to accept the filing date?
See, so there's the good question. If it's rejected, there's not an actual receipt number issued to it. Now, in years past, USCIS would look for the completeness of everything, and if you met the requirements, they would open the case, cash the checks, assign the receipt number, and then notify you of the deficiency in the case and allow you through RFE or some other method to go ahead and fix that error. A lot of that has changed over the past 4 years, where even small errors, it rejects complete package. So we have, and the reason I've heard a lot of this happening with those categories is AILA, American Immigration Lawyers Association, is working with the liaison office with DHS to try and see what we can do about, if this happened, a resubmission process. So I think that's still in the works as far as communication. and I believe everything should be fine as far as resubmission. I know there's traditional methods of, nunc pro tunc and other things like this where we can show if it's no fault of the applicant, they're maintain their non-immigrant status as how it's been before, and they're not in removal proceedings. That typically that's something that USCIS will accept for a filing. And nunc pro tunc is just a Latin term where it's basically they're going back and basically accepting the filing as if it were filed at that time back at that previous date, so it's filed properly.
Okay. So even I see a couple of rejection on the not represented the alien number. Is that important to enter? It means provide the alien number in 485 application?
Correct. So when you file any type of petition that gives you an immigrant benefit or would give you an immigrant benefit in the future, what that means is the government's going to assign you an A number. Now, a lot of people think, well, when I was a student, I also had A number on my EAD and things like this. And, technically that's not true. There is a number that's associated with that we use certain times for H1B filings, especially during cap season, that allow the service to identify that person not only through their CVIS ID, but also through that A number associated with work authorization. But when you get an A number, it's going to be like a 9-digit identifier, much like a social security number. And, this will be associated with your A file, which stands for alien file. And there's actually going to be a physical file categorized under your A number, and it's going to have all the petition documents, applications, everything in there. So it's very key. If you don't have a corresponding A number to your application, how is the service going to find the previously filed I-140 or associate it with your A file? And like I said, in years past, if you didn't include that, it wasn't something that was fatal to the filing. They would, allow you to have a chance to cure that or correct it as long as the majority of the application was there. But now these